Today we're going to be talking with Linda Cheek and Summer McKeivier. Summer's with the Chapman Law Group, and she's one of the healthcare fraud defense attorneys who specializes in defending clients facing charges of healthcare fraud and drug trafficking and other white-collar federal criminal statutes. Summer practices in the Los Angeles area, but also defends cases nationally for Chapman Law Group on behalf of clients. Hi, Summer. How are you today?
I'm good. How are you, Ron?
Great. Thanks for being on the show. And also, we're welcoming Linda Cheek back. Linda's been on the show before, talking about doctors prosecuted under 21 U.S.C. 841, the drug trafficking statutes. Linda runs Doctors of Courage, which is a website devoted to outing the government's efforts in combating the opiate epidemic through charging doctors. She has a wealth of information as a physician herself about doctors who are being prosecuted. And she's also done a significant amount of study on cases against doctors across the United States for quite a few years. Thanks for coming on the show, Linda.
Thank you, Ron. Thank you for having me.
My pleasure. Well, today we're going to talk about 8 signs that you hired the wrong healthcare fraud attorney. And I think we've got a list of about 8 things to go through, signs that you might have hired the wrong healthcare fraud attorney. And I'll start off by saying there's many attorneys out there who are advertising services on behalf of doctors. Many of them are DUI attorneys who have found that they might make a little money doing healthcare fraud defense, and so they put it up on their website. Many don't have the requisite experience. Many of them have never been in a federal courtroom before, but many of them are very quick to take a doctor's money and seek to defend them. And one of the things we want to do is give you the right tools to know whether or not you hired the right healthcare fraud attorney. And if you haven't, give you the option to change before you go to that trial, conviction, and potential sentencing. So let's start with the first one. Number 1, Summer, lack of trial experience. What's one way to tell that an attorney has a general lack of healthcare fraud trial experience?
Well, I believe the best answer to that question, Ron, is going to be when you are interviewing your attorney in the beginning and that attorney doesn't have the terminology. Healthcare fraud in and of itself and the practice of medicine has its own terminology. And it becomes very prevalent and very relevant in these types of cases. So when speaking to an attorney who doesn't have experience in this area, you will quickly understand that they are not the attorney focusing on healthcare fraud and can probably help you the best because they won't understand the different terminology used in this area, and particularly CPT codes, ICD diagnostic codes, and things of that nature. But in my experience, that has been the very bright neon light clue that an attorney is not prepared to focus and understand healthcare fraud to the nuances that you need to for these types of cases.
Thanks, Summer. And Linda, turning to you, why would it be important that an attorney defending a healthcare fraud case has actual trial experience in defending cases like that?
It's extremely important that they have trial experience because they have to know what direction the prosecution might take in attacking their client and be able to have the proper tools in which to put those particular attacks down so that they can know what to go back to look at prior to the trial and have all those all the paperwork necessary for trial. And if they can't do that, if they don't know the information necessary to defend the doctor, they're not going to make headway during the trial, and you've wasted your money. You're going to get convicted.
That's a really good point, Linda. Summer, through your trial experience, which I know you have an extensive amount of it, have you learned tactics or procedures that you might use for defending physicians accused of healthcare fraud that some who don't have that type of experience may not be able to use?
Well, I'll start by saying this. I think that inexperienced attorneys or inexperienced trial attorneys in this area are going to look at the discovery and the information or the evidence that's provided by the government. And if they see any differentiation between, let's say, the billing and the actual, services or whatever, the government is going to immediately say, okay, there's a difference, therefore there's a crime. Well, for healthcare fraud, the real focus should be on the definition of healthcare fraud under the United States Code, which is a scheme or artifice to defraud. nowhere in any criminal code is a mistake considered a crime. And a lot of times that's what happens. Doctors want to focus on the medicine. They don't want to focus on understanding all these different codes that they have to. And for a majority of them, because it's such a complicated area, and not just complicated, but ever changing, always changing, not only among the different insurance carriers, but also Medicare as well. As you know, Ron, the rules change constantly, and not only that, they are sometimes different in different locations, different geographical areas. And when I say the rules, I'm not saying the laws, I'm saying regulations. And violating a regulation is not a violation of a criminal statute. You can make a mistake. And in fact, you can make a mistake repeatedly for years because you've understood a certain coding when billing your services to be a certain way. Now that may have always been inaccurate. You may have been wrong from the beginning, or it may have at some point changed slightly with the new regulations that get implemented almost yearly, not only, like I said, in the geographical areas, but overall. And doctors don't want to constantly be reading updates on codes, updates on local coverage determinations and things like that. They just want to practice medicine. They're focused on reading the New England Journal of Medicine, not the CPT book, not the Medicare guidebook. And the problem with that is that, just like we all do when we download an app, we immediately click, yeah, I got the terms of service and I understand them and here you go, I agree to them. And that's very much what it's like with the Medicare manual. Most doctors just sign it, hey, I want to become a Medicare provider. They sign it and they don't really understand what it's saying. And in it, it makes it so that you are responsible for knowing all of these differences and changes as they come. And so to have begun a mistake in billing and continued it throughout your practice, and then all of a sudden, the federal government comes knocking on your door and says, hey, you've been defrauding the government and now we're charging you with healthcare fraud, is not necessarily true. It could have just been a mistake that was continued throughout. And a healthcare fraud, an experienced healthcare fraud attorney will look at that and understand and be able to present a defense based on the fact that what your data shows is consistently you've gotten it wrong. Not that you've changed your coding in an effort to defraud the government to get higher reimbursement, but just because it wasn't something you knew and you had been doing it from the beginning. And a lot of doctors, unfortunately or fortunately, like we all do, rely on professional coders and billers. And that is something, that is also, in my experience, a very murky area because this is just a certificate. People can get it online. They're called a professional coder and biller, and you hire them and you pay them a lot of money. But at the end of the day, the government is not going to knock on that professional coder and biller's door and say, you've been defrauding the government. They're going to knock on the doctor's door, the doctor who signed that Medicare enrollment form, the doctor who's benefiting from those reimbursements. And, the I have a biller and coder defense, while important and valid, is just not how it's not going to stop you from being the one sitting in a courtroom. And I think that doctors, to some degree, have to be knowledgeable in billing and coding because they're going to need to know whether or not their billing coder is doing it right. But more importantly, their attorney is going to need to have the experience to be able to determine whether or not this was actually a scheme or artifice to defraud and not just some mistake that has been continued by the doctor and their biller or whatever, or whoever they're using to help them with that.
Well, that's absolutely something I've experienced. Many inexperienced attorneys don't know the difference between billing and coding mistakes and healthcare fraud. Healthcare fraud requires much, much more. And that's something the government gets wrong all the time, too. They charge mistakes. Let's go to number two. Go ahead, Linda.
I could give a personal testimony for that. Back in the early 2000s, when they were first trying to set me up to attack me, they did charge me with healthcare fraud. But one of the things that I didn't have as a problem, and which could have been, was what's called trigger point injections. Early on, when trigger point injections were first created, invented, or whatever, the billing allowed you to charge per injection, like $75 that you got back from Medicare for a trigger point injection. So if you just did 5 trigger point injections, you could make several $100s, and it was good money. I can guarantee you that. I was actually doing that in the beginning of my practice, and it was legitimate. But then in the early 2000s, they changed the codes so that you had to do 1 to 5, 5 to 10, 10 to 15 in order to get different payments. If a doctor was still doing the charging for the single injection, but didn't know about the change in the CPT code, they could, be charged with fraud when really it wasn't fraud. It was a simple mistake. But that would be something that would have to be, discussed and planned. So, I mean, that's just an example. The American Medical Association gets paid for creating these CPT code books. So they change them every year. So the doctors have to buy the new ones and they make their money. And so, it's just part of the process. But like you say, doctors can't go back through and say, okay, are all these codes that I've been using now for 5 years, have they been changed? And they get hung with that. It would be really nice if the government would, if there was a problem with somebody's coding, if the government would come to you and say, this is something you're coding and it is incorrect, and then give you the chance to change the way you coded before they charged you with a crime. That would be nice, but I don't see that happening.
Yeah, Linda, you're absolutely right. In fact, they're still charging cases today where they're alleging that doctors overutilized the trigger point injections and therefore it was a fraudulent scheme. But in reality, simply violating regulations, as Summer said earlier, is not fraud. Creating a scheme to defraud the government by violating those regulations is fraud. And that's actually a jury instruction that we would usually seek to get introduced, that many inexperienced defense counsel may not get introduced. So let's go to number 2. And this happens to me all the time. I get a phone call from a client who is seeking to detain us, and pre-indictment, so the client has not faced any formal federal charges yet. And I say, what has your attorney done for you so far? And they say, nothing. He told me that we don't want to ruffle the government's feathers, and so we're just waiting to see if we get indicted. And we'll engage in plea negotiations before the indictment happens. And I call this the let's let the sleeping dog lie defense. And I think it's absolutely one of the worst ideas in white-collar federal prosecutions. I'll start with you, Linda. Linda, do you have any perspective into that? And have you seen that happen before?
Yes, all the time. And pertaining to healthcare fraud, I would suggest to doctors that are listening to this that one of the keys in determining whether or not you are going to possibly be a target is if your records are being taken by, if Medicare or Medicaid is coming and asking you to submit records for them for their review, so to speak. That happened to me 3 years in a row during January, which is the most trying time for a doctor fighting influenza and colds and everything, to have to come up with these records to send to the government. And I actually called them and asked them, why are you asking for my records 3 times in a row? And the answer I got was, oh, there's nothing particular. You just happen to be arbitrarily chosen. But I would suggest to doctors that that's a clue that they are investigating you, and to immediately look for good representation to be prepared for that indictment if it should come down. But the sleeping dog lie thing is pretty much paramount amongst standard white collar attorneys that really do not know what they're faced here, and they think that if we just they put the head in the sand. It's the old ostrich approach. If we ignore it, it'll go away. And the doctors think that the more time that passes, a month turns into 2 months, turns into 6 months. Oh, they haven't found anything wrong. I know that's what I felt. I thought as time progressed, okay, I'm safe. There's nothing wrong. They're not charging me with a crime, and everything's okay. And then, eventually you get the indictment. So yeah, it's a major problem with lawyers who don't know what they're doing, basically.
Yep, no news is definitely not to be considered good news when we're dealing with the federal government. Summer, I'd like to turn to you. What should attorneys be doing instead of saying to their clients, let's let the sleeping dog lie?
Well, if the government gives you the gift of tipping you off by Medicare asking for your records, like Linda said, or coming in with a search warrant or anything like that, prior to indictment, that's a gift, because one, it's going to give you the time to begin doing a parallel investigation. At this point, what you know is that Medicare or the government, I'm going to lump them in together, are investigating you. So if your records have been seized or if your records have been requested, you need to be making a parallel copy of those to provide to your attorney. Because at the same time the government is sending those records to their medical expert or whomever, or their billing and coding expert to review, your attorney should be doing the same and doing a parallel investigation. And letting the sleeping dogs lie puts you behind the 8 ball. Because once an indictment comes down, the government has pretty much done their investigation. I'm not going to say that they've stopped. They won't stop. They'll continue to prepare and maybe try to find more. But they've done everything that's going to have taken a lot of time. And like Linda said, you're sitting there saying a month has passed, 2 months has passed, and you're thinking, oh, well, they must not have found anything. Well, that's just not accurate. They're still looking at it, and they know they have plenty of time to bring this case against you. So they're not really in a rush. And so, 3 years down the road, you've gotten your records seized and you've done nothing, or your attorney's done nothing. Now they're ready to go, and you're going, okay, give me all those records so I can give them to my expert. Now the problem is you have to wait for those records in discovery, or these are records that your attorney has to go down and either make copies of, which is going to cost you a lot of money, or try to review themselves out of all your records, which ones are pertinent for your case. Because of HIPAA, they don't always give you everything you want, and they certainly don't always give you everything you want up front. It takes a while to start pulling teeth, even though we have discovery rules. I sometimes find it very difficult to get everything I need right here in my office so I can get started. So I would say, if your records are being seized or requested, make yourself a copy as well, because we're going to need those. But more importantly, if you're having a knock on the door and DEA or FBI or HHS and as agents are asking to speak to you, or they're asking to come in and take some of your records, then you need to be making a copy for yourself. And you need to know right now, there's an investigation and I need to prep, because you can do so much more prior to an indictment being issued than you can once that's become stamped on an indictment and we're going forward on that.
Absolutely. And let me add 2 things to that. First, the parallel investigation advice is vital. Whenever anybody is being suspected of any wrongdoing, whether it's just an audit or investigation, or maybe you're the target of a federal indictment, a parallel investigation is absolutely necessary. And the second thing is that if you are waiting while the government does their investigation and not doing your own investigation, you need to remember that the best time to talk to witnesses, to preserve evidence, to get information about your case is before your name appears next to the name of the United States on a federal indictment. Because this strange thing happens when you're charged with a federal crime. Nobody likes you anymore. Nobody wants to talk to you anymore. Nobody wants to help you anymore. So the best time to get information about your case is before you end up getting indicted. That way you can preserve the testimony doing an internal investigation of your office staff, preserve the testimony of your medical biller, preserve the testimony of patient witnesses who you might be able to interview. And those people are much more likely to say good things about you, and also to even speak to your investigator or provide information before the United States finishes their investigation. And also, sometimes the United States isn't in a position to interview those people yet. So you may get a jump on them by talking to them first. That's why we've got to do that good parallel investigation right up front. Let's move to number 3. Number 3 is something I commonly see. It is the generalist criminal defense attorney operating in the highly complex and specific world of healthcare fraud. Summer, I'd like to start with you. Have you seen instances of general attorneys appearing in the courtroom on behalf of their clients, and what do you think about that?
Well, actually, Ron, I can speak from experience. My entire career, I have been a federal criminal defense attorney. And in the beginning, and for the first few years of my career, I was a generalist. I did all federal criminal defense, meaning I defended people against all crimes against the United States. In that practice, I had a couple healthcare fraud cases. And what I can say looking back now that I have been primarily focused on healthcare fraud law is that I certainly was most likely not prepared and did not have the experience in those cases that I did when I was a generalist that I do now. I know so much more, and the experience of doing this is vital when you're defending these cases because, one, a general criminal defense attorney or federal criminal defense attorney is not going to understand how time-consuming these are. I mean, these are data-driven analysis. And they're not, again, like I said in the beginning, they're not going to understand a lot of the terminology. So they're really not even going to know what they're looking at and if what they're looking at is important to the defense because they won't understand how it plays in. Like I said, CPT codes and things of that nature. So absolutely, you want to, just like if you were going to have open heart surgery, you're not going to go to your family doctor, you know? You need someone who focuses only on this kind of crime because this kind of crime has so much nuanced information. It's like learning an entirely different area of law. It's not, although it's considered criminal defense, it's just not the same. And I absolutely, I believe in these particular types of cases, you have to find one, the defense attorney who understands healthcare law and is focused on that, but two, also understands how time consuming they can be. Because this is not just about reading some interview reports of the witnesses and saying, okay, now we can go to trial. And, you know, this is about actually going back and checking the government's work. Because you have to remember, the government are not doctors and they're just agents and attorneys as well. And they don't always know exactly what they're doing because we are trying to judge or, you know, well, they're trying to judge, you know, a doctor's practice. And as we all know, where there are regulations, there's certainly not only one way to practice medicine. And one patient could have different answers and different treatments from, you know, 5 different doctors. It can all vary dramatically. And it doesn't mean that anyone is right or anyone is wrong.
Absolutely, Summer. And I appreciate your personal experience with the issue and your journey from being a general federal criminal defense attorney to now one of the best, I would say, healthcare fraud defense attorneys in the country. It certainly is a significant change and provides a lot of benefit to our clients. Linda, I'd like to turn to you. Have you seen a difference in the results through your work with Doctors of Courage that general criminal defense attorneys get for their clients versus specific healthcare fraud or, I guess, attorneys who represent physicians in federal cases? Have you seen a difference in the results?
I'd say the big difference is winning versus losing. Generalists generally lose, and specialists can win. Not possibly not 100% of the time, but at least a lot more percentage than the generalists do. It's just like, you know, like I think perfect example there is the family doctor is not going to do heart surgery. But the problem is doctors consider that a lawyer can cover pretty much anything. Even though if you go to buy a house, you don't take that to a lawyer pertaining to a divorce, you take it to a real estate lawyer. But for some reason, criminal justice or criminal law, they seem to think anybody that's, quote, a criminal defense attorney can cover their case, and that's really not the case. So they really do need specialists. I do not know what the, you know, where you go is, I guess it's just in the case of that initial interview, you have to get the information from the potential attorney as to how many of these cases and what their experience has been in the field. No.
Yeah, that's a really good idea. I will tell you personally that about 80% of the cases that I take are taken over from a generalist. Here's the problem. That generalist has often spent a considerable amount of money, finite resources, and chewed that up in furtherance of defenses that aren't going to work. And so when I get a case, sometimes I now have a client who has diminished resources and ability to get the right experts, get the right, obviously, attorneys on their side to make it work. Many times we're able to fix it and make it right. There are many doctors I can't help because they've spent everything on a generalist who is pursuing the wrong goals in the wrong direction. On that note, and sort of as a segue, number 4, beware of flat fees and low fees. Summer, there's attorneys out there who accept small flat fees for their clients. There's also attorneys out there who sort of get their clients in the door by offering them a low fee. Why can that lead to trouble, and why is that a potential red flag when looking for a healthcare fraud defense attorney?
Because once they start to look at a healthcare fraud case and start to prepare a healthcare fraud defense, what they're going to understand, if they know what they're doing, is what they're soon going to learn is that these are very time consuming, they're very labor intensive, and they're going to end up taking up a lot of their time. So if they've given you a flat fee rate, let's just start with those, because those are very common in criminal defense, and they're useful to some degree in some areas of criminal defense. Not all people have, the amount of money to say, I can go from the beginning to the end and afford an hourly rate, because what you won't understand is how much time it's going to take. So a lot of criminal attorneys use flat fees to make that part of a case, solid and understood, so the client feels better there. But what's going to end up happening with those attorneys is they're going to come back to you when they realize that this particular case is complicated, and they realize that you want to go to trial. And these cases are long trials. Let's just be frank. I mean, there's a lot of information to be put on. They're not just, week-long trials ever. And what they're going to do is, one, because they've taken a flat fee or a low fee, they're not going to want to take it to trial, because that's going to take them out of their office and making money on other cases for a long period of time, which ultimately is them losing money. So they're going to pressure them to plead. They're going to push them towards a plea agreement. And if they don't do that, and there may have well been a defense, and if they don't do that, then a lot of them, and if you're not savvy as to the ways of retainers and how it works, a lot of them are going to ask for an additional fee. And if you haven't read the fine print of your retainer agreement, you're going to understand that you owe that additional fee. And if you don't pay that additional fee for the trial, then they're going to try to withdraw as your attorney. Now, the problem there is you just paid this very large upfront flat fee that you didn't realize didn't contain a trial, it didn't cover a trial. And now you've got to start completely over, not just with getting a new attorney to go to trial, but that attorney now has to go and catch up on your case again. So basically they're going to do everything all over, which means you're probably going to be paying similar to what that flat fee is you've already wasted, plus the trial fee now for that attorney, because they're going to make sure that their time is covered too. And that ought to me, and a lot of attorneys just want to get you in the door and get you, get a check and get started. And I'm not saying they're not going to do the work, but I tell you that once they realize how much work it is, they're going to realize that it's going to hurt their bottom line. And, when you're not in the office as an attorney, you're losing money when you're not available to clients, and they're going to try to make up for that in some way.
Yeah, those are very good points, Summer. Linda, I don't want to betray any confidences here, but I know in your work with Doctors of Courage, you've had conversations with a lot of doctors who are facing federal indictments and often very stressed out about their legal defense. Generally, have you seen this issue come up, and have you seen doctors that are frustrated or even injured by the fact that their attorney charged a flat fee and isn't doing the work for them?
The how they got paid has not really come up in our discussion, but just the fact that they're unhappy with the way that the defense is going, and they're looking for other another solution, another defense attorney. And of course, like Summer says, that just means you are repetitively paying the same money over and over and over again. Whereas the smart thing to do would be to pick someone who basically knows the steps to take, so that they're not having to go back and relearn their law school directions for healthcare fraud, and doing and spending all that time. Time is money, to learn how to defend. You go to the person who knows what they're doing and doesn't really need to do all those initial learning steps, and then end up having to pay all that over again, hiring someone else.
Well, that's a very good point, Linda. The generalist who doesn't know healthcare fraud, who's being charged an hourly rate and maybe not a flat fee, is really charging you for their own education, and that's a problem, because when you're paying an hourly rate, you shouldn't be paying for an attorney to learn. When you hire a specialist, you don't have to pay for that education. And I'll just offer some comment on this. I think that selecting an attorney in many ways is like buying a suit. I've looked at all the suit brands out there before, and there's no way to get around it. Buying a cheap suit is going to wind you up with a cheap suit. That's just how it is. There are no cheap, amazing suits out there. At the end of the day, good wool costs what good wool costs, right? And so if you spend the time in looking for the right brand of suit, and you spend the time in understanding exactly what type of suit you need to get that will last you for years and years and years, right? And you spend a few bucks on getting that good quality suit, that good quality suit will be with you for life. Same thing with finding a healthcare fraud attorney. If you spend the time to research the right counsel, if you spend the money on getting the right counsel on your side, you're just going to end up with a better deal overall, instead of having to rebuy that suit, in a couple of months or a year. And as you said, Linda, sort of having to pay for somebody to get all of that knowledge and wasting that knowledge on the attorney who had to withdraw. So certainly clients, beware of flat fees and beware of low fees. I will put a caveat there. There are many attorneys who do accept flat fees that are reasonable and sufficiently provide for the defensive client. And so flat fees aren't all bad. Just very low flat fees offered by counsel are generally a bad sign or a red flag. Number 5, I hear this all the time. I know the judge, I know the prosecutor, you should hire me. Summer, should clients be weary when they hear those words?
It's actually really of no relevance. It's certainly of no benefit. In my experience, it's likely more of a detriment. My entire career, I have been a federal criminal defense attorney, and I have practiced nationwide, meaning I practiced in almost every district court in every state in the United States. And I can tell you that I have never had an experience where being from somewhere else, not being from the local area, has affected my client negatively in any way. What I can tell you is that it has impacted my client and my client's case positively, mainly because when you're an attorney from a certain area, small areas in particular, knowing the prosecutor or knowing the judge, and I will say, knowing the judge is not going to be any benefit to you really at all. These judges are appointed by presidents. They're federal judges. They know what they're doing. They're going to do what's right. They didn't get to the federal bench by being someone who could, get around to golf and cocktails and start, making deals and making their legal decisions based on friendships. So what's really more important is focusing on the prosecutor. And that's because while there's really no watchdog group that is overseeing prosecutors, although they are held to a certain standard, the only people who can really hold them to those standards or point out that they may not be attorneys. And when you hire a local attorney, a lot of times what they're taking into consideration is, I have to be in this courtroom more often. I have to go there daily, or this is where I mainly practice. I have to deal with this prosecutor a lot. And that interferes with their ability to sometimes defend you fully, because they don't want to ruffle the feathers of that prosecutor, because down the line or next week, they may need that prosecutor to offer them a deal or offer their another client a good deal, or be helpful in some way on that. And the problem with that is that that's how these prosecutors get away with everything. Mainly, and I'll give you an example from a recent case, without naming any specifics, but the prosecutor, the way that the indictment was filed was 100%, in my opinion, and I think legally, inappropriate. It was wrong. It was insufficient under the law. And I challenged that, and I wanted to challenge that. And what I was told, not only by the local attorney that I was working with, but by the prosecutor, is, this is just how we do it here. And my response was, that doesn't make it right. And the reason why this is just how you do it here is because all the local defense attorneys are not standing up and saying, you're doing it wrong, and I'm going to file a motion, and I'm going to argue in front of this judge, and I'm going to argue in front of the Court of Appeals if I need to, because the way that you're doing it is in violation of my client's constitutional rights. And they get set in this pattern because no one's challenged them, and they just do it that way. And that's a problem. And that's a problem setting precedent in the country, but more important, it's a problem setting precedent in that area. And, with someone from out of state or out of town, like me, and someone who also knows that area of law, I don't have that impediment of worrying about that. Not that I would anyway. I mean, Ron, you know that you and I do a lot of cases in the Eastern District of Michigan. And all I can say is, do we know all those prosecutors? Sure, we do, because there's a healthcare fraud division, right? Do we know the judges? Yes. In any way, shape, or form, does that stop us from challenging them? No. And I think that's actually become quite beneficial, even though that might be an area that a court that we commonly practice in, because one, you and I don't have any problems with those U.S. attorneys, but what they know from the very beginning is, one, we're going to be respectful and it's going to be a professional relationship, but two, we are not going to let anything slide. And I know, I'm pretty sure, just, from experience, that you and I have changed the policies in the U.S. Attorney's Office in the Eastern District more than once.
Oh, yeah. And in other states as well.
They're prepared that we're going to come back at them and that we're going to say, right.
And here's the thing. It's one thing to actually know a prosecutor. It's another thing to tell a prospective client that you can get them a better result because you know the prosecutor, which is a very, very damaging thing to say. I'll also point this out. In terms of changes to social justice, we've got an issue going on in our country right now. The healthcare providers are being attacked. Healthcare fraud statutes are being expanded to criminalize all conduct. And the only way to change that is on a national scale. And local attorneys are not changing the landscape of the laws. They're not making the right challenges. They're not getting the right issues up to the appellate courts to change things for doctors for the better. What this is going to take is a national effort. And that's what we're trying to do at Chapman Law, to get a national effort through all of these victories to get the law in the right direction so that more doctors don't need to be attacked. Linda, do you have anything?
And Ron, if I can expand on that, Ron, for just a second for what you just said, just a little bit. I would say absolutely, and that's what makes what's been interesting about what we do and the fact that we're nationwide, and is that's very important, is what we're finding when we go to each of these districts is that we're being pigeonholed by, this is just how we do it in this district, and we're the only ones who are challenging it. And why are we doing that? So that when we go to the next district that says this is just how we do it, we can say, look, we've changed it here, we're bringing it here. Because you're absolutely right. These healthcare fraud statutes were not meant to be as broad as the United States government is making them, and they're doing it consistently around the country because, just like you said, local attorneys aren't challenging them. So I agree, the best thing that we're doing is getting these cases in other areas, because it's not just benefiting our clients, but it's benefiting us as defense attorneys, so that every time we walk into a new case, we don't have to say, okay, let's go teach the government again that this is wrong. We're starting the precedent one place and hoping it travels from district to district.
That's absolutely right. Linda, do you have anything to offer on that?
Well, I just have a question for you, Ron. In pertaining to this, lawyers that are selling themselves based on who they know, what would you say about the lawyers who have been prior prosecutors or U.S. attorneys taking now the defensive doctors in these cases, and them saying, well, I know how it's done, so I'm the best attorney that you could get? How would you respond to that? Or how would you warn doctors that are about to step into that trap? I think it's a trap in their choosing of an attorney.
Yeah, Linda, that's a fantastic question, and there's many ways to answer it, but I will say this: once upon a time, when I was a young prosecutor, one of my colleagues, who was much more senior and older than me, said that in his experience in watching young attorneys grow up, he has found that you are what you were first. If you were a defense attorney first, your mind tends to be more defense oriented. If you were a prosecutor first, your mind tends to be a bit more inflexible and rigid. And now, there are many good former prosecutors who have become fantastic defense attorneys. But I will tell you this: a career assistant U.S. attorney gets out of the office and turns into a defense attorney is generally not as creative as career defense attorneys, all right? I haven't seen the type of fight in them that I would see in a career defense attorney. And while they may have a lot of friends in the office that they're working around, I've noticed that those friendships sometimes prevent them, as Summer has indicated before, from fighting as aggressively on behalf of their clients that they need to. And I generally see just this common kind of vibe from these types of attorneys that they're less likely to believe their clients when the conduct looks potentially criminal. They don't give their clients as much of a benefit of the doubt. So I want to be clear. There are many former prosecutors who are fantastic attorneys. I was a former prosecutor. Interestingly, I was a defense counsel first. And one of the reasons why I stopped being a prosecutor is because I didn't want my talents to be used to put people in jail for crimes that were sort of overexpanded beyond what they really should have been. And I'd rather use my talents fighting the federal government and trying to seek justice on behalf of.
And Ron, just to expound on that just a little bit, it's like, you started school and you were right-handed and you wrote with your right hand, and then somewhere in your mid-30s you said, you know what, I want to be left-handed. It just doesn't work like that. You're right. Your brain starts to focus, and this is the way you learn something. But what I found with former prosecutors becoming defense attorneys is that they don't understand or realize how much work it is to be a defense attorney. Because as a prosecutor, it's all right there for you. Just pick up the phone and make a call. Hey, I want a document. Oh, well, you're the government. Some agent's going to run out and get you that particular document. Maybe you have to rubber stamp a subpoena or something. Oh, I want this person interviewed. Well, you just call up your FBI agent or your HHS agent, and you say they go and do an interview for you. And as a defense attorney, you're not only knowing that you need those interviews and those documents, right? You're also having to find the appropriate person who can serve as your agent, your expert, your interviewer, your investigator, and things of that nature. And I don't think that, one, they always have the resources because they have to find them. They're not just sitting over there in the FBI building. And two, they don't always understand doing that while balancing a client's expectations and budget. Because as a prosecutor, no one's coming in and saying, you're spending too much money. It's the government's money and you work for them and they just want you to go and win. So they're not coming in and saying, sorry, you went over your budget on this criminal case, we're going to shut it down. They're not going to do that.
Yep, that's absolutely right. And that's I think sort of our collective experience, that there can be good former prosecutor defense counsel, but I think some of the best I've seen were defense counsel from the beginning and are able to think creatively and attack cases creatively. Let's talk about number 6. I see this mostly with big law firms and with big name partners. Sometimes what you pay for is not exactly what you get, and we call that the bait and switch. You want the best name in town, you interview with that person, he quotes you a fee that you can afford, you spend a lot of money on that person, and maybe it's a flat fee, only to realize that slowly but surely your meetings are starting to occur with associates or one associate. The partner's not showing up at things anymore. Next thing you know, the partner's out of town and the associate's got to report. And then you realize you've been the victim of the bait and switch. The partner retains you and the associate is trying to do the work. Linda, have you seen that tactic used before?
Personally, no, not me. I mean, on my teams, they were very small organizations, not the big ones. I can see it though in a large, if a person does have a large or a big named associate attorney that they talk to start with, I can see that would be a typical occurrence with the big law firms. And of course, then that's going to cause a lot of disgruntlement among the defendant's perspective that he's not getting the person he thought he, quote, paid for defending him. And that can set up a lot of rift then even in the defense, trying to work on your own defense. So I would consider that to be very harmful if that was done.
Yeah, Summer, how can clients protect themselves from the bait and switch when they've hired a big name partner, but they're starting to see an associate show up more and more?
Well, I'd have to say it like this. So we're the Chapman Law Group. Clearly you are Ron Chapman. And sometimes I'm not available when a potential new client may come in for an interview, and sometimes you're not available. And a lot of time, the potential new client may get married to the person who they interview with in the beginning. In our firm in particular, it may happen where you've interviewed someone, but this is a case that is more in my wheelhouse. For instance, I think the pharmacy cases we've really come down to say, hey, when we get a pharmacy case, that's going to come to me, even though you may have interviewed them, because I delve into the logistics and the numbers deeper, and it's just sort of somewhere cases that I've had a lot of, and so I kind of see what the government's doing and where they're going and where they have failed to go and need to go as far as information. So, I will say that I think it is common in law firms to do that. However, what I would be weary of, and I'm not going to name any names, but there are particular law firms out there where the name on the door is just a figurehead. He or she is not really an attorney who goes and does cases. So they'll throw your name on your case. They'll file an appearance. But the truth is, they're not doing that for any other reason than sort of to protect themselves, right? They're not reading your case. They're not looking at it. They've got some person locally in that area that they've, thrown a little bit of the fee to and said, go handle it, right? And those firms are, in my opinion, problematic. I think they should be shut down because that is false advertisement, 100%. And the difference between that and us is, while you may have talked to Ron Chapman, or while you may have talked to me and it went somewhere else, we really do work in the same place. We really do call each other, daily. We, now as COVID, clearly there's a lot of videoing, but for the most part, we can be in the same office if we need to be. My office is just down the hall from you right now. I'm just at home. But in those cases, we are actually working as a team. While you may have interviewed, the client may have interviewed with you, you will likely tell them up front, this is a case that Summer's probably going to handle. It won't happen, where all of a sudden they just get a call from me and they don't know who I am. Most likely, my name is going to be mentioned in that first interview. They're going to be aware of me. But more importantly, we're going to work as a team anyway. And while I may, for instance, take the lead, I will be talking to you to say, what do you think about this? I want to file this motion. We did this the other day where I called you and I said, I think there's a huge mistake by the government. I want to file a motion. The problem is I think that we have some liability too, that kind of thing. But you and I text and email and talk very regularly. And I'm also one of the senior attorneys there. Now, do we have associates? We do. We have associates. But we're not about to throw some associate, but they also, again, work in the office with us. And we work closely with them. And their work product doesn't go out without going through one of us first because they're learning. But, that's, to me, is perfectly fine. That's how a law firm works. You can't have one attorney who does everything. Nobody has that kind of time, But we're never going to just say to one of our associates, okay, we just got this client, here it is, go do it, and not in any way, shape, or form have oversight, or not in any way, shape, or form not know that person. And I just think that happens quite a bit with these nationwide firms where you see these big names. Because if you look closely, you're not going to see anything where that person files any of the motion. Like if you look at the docket, for instance, If you go and look at the name of the person, you're not going to find that person's name filing the motions, going to court, and doing the arguments. And in our firm, you are. You're going to find either your name or my name.
Yep. No, that's correct. Some people, some firms work in teams very well. Some firms have associates like ours, but there's a big difference between the bait and switch and those approaches. Linda, did you have something to offer?
And just with my one experience of a law firm that actually had more than just the head lawyer, the team approach I think is really good because then, he actually addresses the fact that this person has expertise in this area and we go to him for questions here and then this person. And that way the defendant actually knows who is contributing and that they are contributing areas that they are experts in, which actually makes the team more valuable.
Yep, absolutely. Very, very good point. So let's go to number 7, lack of expert support. I get this phone call quite often from attorneys who are defending a doctor somewhere across the country, and they say, hey, listen, having trouble finding an expert, don't know how to find one. Can you give me the names of some of your experts? Now, pardon me for saying this, but the first thought that goes through my mind is why did you ever accept a case where you don't know who to turn to for expert witness support? Summer, I see, it looks like you're ready to handle this one. What do you think about that approach, about those attorneys who accept these types of cases but lack expert support or context?
Well, let me just start by saying if you have been indicted for healthcare fraud or opioid diversion, unlawful distribution of opioids, or anything like that, these cases, know from day one when you walk into an attorney's office, you're going to be hiring an expert. If you don't hire a medical expert and also a billing and coding to some degree expert too for healthcare fraud, if those aren't hired, then your case has not been properly prepared. You have to have that. We are not doctors. We are not billing and coding experts. But more importantly, even if we were, we can't testify on your behalf. So there should always be an eye towards trial. And if you're going to an attorney who doesn't know, one, what kind of expert to hire, or two, have a stable of experts that they have used and are familiar with and know their work product, then you're going to be in trouble, because much like starting with that inexperienced attorney and then giving us a call because we do healthcare law, you're going to have the same problem with your expert. You're going to have an expert report and your attorney is going to review it and go, this is not coherent, or this doesn't make any sense, or this is nothing what I needed to be focused on. The medical experts that an attorney hires need to also understand the law, because you're preparing this expert as a defense to this crime. So it's not just come and stand up and say, here's what I know about medicine. It's here's what I know about this type of medicine and why this is not an unlawful distribution of an opioid, right? It's not just, how opioids work. But yeah, I mean, if your attorney doesn't have experts that they know and like, what that tells you is that they don't have experience in this area. And if they don't have experience in this area, it should tell you right now, this is not the attorney for you.
So Linda, let me ask you this. With your knowledge of all of these cases throughout the country, have you seen mistakes being made with respect to the selection of an expert or the availability of expert testimony in defense of these physicians?
Personally think that that's the primary reason why doctors are being convicted, is the improper choice of a medical expert. The problem is that they are nitpicking. The government is nitpicking. I'm not talking about healthcare fraud. I'm talking about doctors being attacked for prescribing opioids or any other controlled substance. And that is the nitpicking of record. A very good source for the history of this is Ronald W and his book, The Criminalization of Medicine. And he has an entire chapter devoted to why chasing medical records is not a proper way to go. This has been happening now. His book was written in 2007, and this has been going on now for 20 years. And we should be looking at the definition of insanity, repeating the same action over and over, expecting a different result. And we're not. And so nitpicking medical records, putting a defense witness saying, well, they did this right, they did that right, they did that right, against a government witness who is paid, by the way, somewhere in the neighborhood of hundreds of thousands of dollars to say, well, this T wasn't crossed and this I wasn't dotted, and just the propaganda that's in the minds of the jurors, you've got a slam dunk case for the government. So, the choice of a medical expert is critical to the efforts to try to make this a federal approach to basically stop the conviction of innocent physicians. So it's very critical. But the standard white collar, I'm going to look at this medical record and tell you what's right with it, versus I'm going to look at this medical record and tell you what's wrong with it, the government's going to win every time.
Yeah, you're absolutely right, Linda. And I'll offer this point as well. Instead of chasing the medical records, as Libby talked about in the book, what you need to do is attack the standard. And finding the right expert who has the right knowledge of the applicable standard in the case and can attack the standard through expert testimony, that's what leads to victory. And that's how we've been able to find victory in many of these cases. We don't put a doctor on the stand to look at the medical records and just offer a contrary opinion. What we do is put a doctor on the stand to say, listen, I know you heard the testimony of a government expert, and I know that person told you that this was criminal activity, but let me tell you it's absolutely not, and here's why. And the things that they will explain is that the standard is much stricter. And an expert gave me this once upon a time, and we've got a network of experts that we routinely use, who've testified for us in many cases, who've written many reports, and whose testimony we can rely on. But one of them, who I use quite frequently, and in order to avoid getting him inundated with phone calls, I won't mention his name, he provided a chart that I still use in every trial to this day. And it lists the various standards for the practice of medicine. The highest standard to achieve is best practices, right? Doctors have to strive to achieve the best practices of their profession. That's hospital rules and regulations and peer review and all of that. The next standard is malpractice, somewhere around the middle. The malpractice standard requires that you basically not be negligent and act in a way that the profession would generally act, right? The next standard below that is the departure from the minimum standard of care. And that's the licensing standard. If you depart from that standard, you've committed a violation that could result in discipline of your medical license or your pharmacy license or whatever professional license you have. And then all the way down at the bottom is the no legitimate medical purpose outside the course of professional practice standard. And to depart from that standard means that the doctor has basically stripped off his coat, right? Taken off the stethoscope, stopped becoming a physician, and instead decided to engage in the practice of drug dealing. It is not the incorrect practice of medicine. It is not practicing medicine at all. And I will tell you, most juries who've sat in judgment of physicians in this country have not been told what the correct standard was and convicted a doctor under one of those other levels of standards that I just told you about. And that's what I just said is part of my closing argument in most cases. And the basis for being able to instruct a jury of that standard is the expert testimony of an expert who can tell the jury what those different standards mean and really flesh it out. Because juries, when they show up in cases, don't know the difference between malpractice and no legitimate medical purpose, or best practices or CMS regulations and the healthcare fraud statute, as Summer described earlier. And having a good expert who knows the difference between those things is absolutely vital in achieving a victory. And if you're with a generalist who you've paid a very low flat fee, who doesn't have trial experience, who trades on the fact that he knows the judge or the prosecutor, or maybe you're dealing with his associate, you're not going to have the benefit of educating the jury on that standard. And that's why we're teaching this lesson to prospective clients and folks who are working with an attorney today. The last one, number 8, let's cover this quickly. The overworked solo practitioner. We've seen this before. The attorney who maybe is my co-defendant's attorney, who doesn't show up to the joint defense conference meetings. He doesn't answer his phone, returns emails, if at all, 2 weeks late, right? Keeps kicking the trial can down the road over and over again. That's the overworked solo. Summer, have you seen an example of an overworked solo before, and what are some of the dangers of that?
Well, I've seen the results of an overworked solo when that particular client either walks in my door and says, please take over the case, or walks in the door too late and says, this is who I hired and I went to trial or I pleaded guilty and this is what I'm looking at. And I start to ask, what did they do in preparation and what was their defense or what did they provide you? And they don't provide. And this all goes back to, many of the other 8 things that we've gone over, other 7 things we've gone over, and that's an experience as well. But I've said this over and over. These cases are labor intensive. Why? Because they're data intensive. Because when you're talking about healthcare fraud, you're talking about billing. To establish healthcare fraud, you're going to have to establish a pattern in billing to show that a scheme or artifice was devised. And the only way to show that is that, the billing, you show that it's not just incorrect, but you can see a way in which the change was made so that you can see the plan or scheme devised. You actually say this is the point where it was devised, right? So that they can maximize their reimbursement, not just simply not understand the CPT code and not understand how to bill it, like we talked about earlier. And that takes time. And not only does it's not just about, we've talked about experts. What's important first is for your attorney to understand it, go look at it and say, all right, I think that this is how I can narrow the issue. And now I've got to find my expert and tailor them to say, go look at this data and tell me whether or not you see this, this, and this, because this is my defense right now from talking to my client and looking at the data myself, right? So you can start with just talking to your client about how they understood the CPT codes, going and kind of reviewing the data yourself and saying, all right, I do see that, and then sending it on to an expert and saying, tell me if I'm right. You know what I mean? But only focus here, because they're going to get this whole Excel spreadsheet of data too. And if you don't know how to guide them, if you don't know how to narrow what they're focusing on, you're going to get one of those inexperienced expert reports where you're like, where in here does it say what it should be focused for a defense? You know what I mean? Instead of just giving me the general knowledge of billing and coding. But a solo practitioner is not going to have the time and the resources to do these type of cases. They're just not. I mean, we couldn't do them. I will tell you, you know, just yesterday, I spent over 6 hours focused on claims and ordering, you know, what I mean, between for a pharmacy review. And from there, what I found was, you know, the government not having everything they needed and double counting some numbers. But a solo practitioner is just going to listen to what the government says. And that's going to be this little spreadsheet that the government made from that data. And they're going to take that as evidence and say, oh, this many orders versus this many claims. And if they don't have the time to go back and actually look at the underlying data where the government got that to see if the government was correct, then you're in trouble. And that's funny because that was one of the thoughts that popped into my head yesterday, because I'm thinking an FDA agent and an HHS agent, clearly they do these cases all the time. They must know what they're looking for and also what they need to get there. And what I found was they don't. And I bet you a lot of attorneys, and originally the first thing I was ever given was just this overall spreadsheet that they created. And it was from persistence saying, can I get the data? Can I get the background data? Can I get the background data so that I can look at it? It was from that I went and looked at what they were looking at, and I said, this is completely wrong. And I can tell you right now that no solo practitioner is going to have the time to do that. They're going to take the government at face value. They're going to say, oh, they're agents. They do this all the time. This has got to be correct because they know what they're doing. And it's just not, that's not true. It's not true. So, you know, not only do you need the experience, but you need someone who has the time to put that into play and not just fall victim to, I know the prosecutor, you know, the local prosecutor, therefore he's a good guy, he's trustworthy. You can be trustworthy and still make mistakes.
Yep, there's much more to these types of cases. Well, there you have it, folks. 8 signs that you've hired the wrong healthcare fraud defense attorney, explained to you by Summer McKeivier and obviously Linda Cheek as well. Linda, I want to thank you so much for coming back and being with us. Can you tell folks on the internet where they can find you and some of your case studies about these types of cases?
My primary website for this is doctorsofcourage.org. And for anyone who's interested in having me as a speaker in the area, then I have a separate website simply for speaking and my authorship, which is lindacheekmd.com. So you can basically, the two websites are have tabs that you can flip back and forth between them. But one talks about me and my personal history, and the other one is primarily talking about all the doctors that have been attacked through the inappropriate use of the Controlled Substance Act.
Thank you, Linda. Well, it's always so good to work with you and so good to see you. And we thank you again for being on the show. And if you have questions about the work that your healthcare fraud defense attorney has engaged in, or you're looking to switch counsel, or maybe you just want that second opinion, we'd be happy to spend a few hours with you for free, going over your case and helping you talk through your options. Again, chapmanlawgroup.com, 248-644-6326. We'll see you next time on Healthcare Hot Topics. Thanks.